Yeah. What would fall under force majeure and what would fall under not force majeure? If you're talking about delays, that is not force majeure.
Hi viewers, my name is Evans from Ravi Homes. Today I'm here with Stella Maraguri from MMW LLP Advocates. We here today to discuss things regarding property acquisition and legal when it comes to you acquiring a property. Myself as Evans, actually I've helped several clients get a property in Nairobi, across Africa and other coming from outside Africa. And our main aims today is just to discuss things to do with the legal framework when it comes to buying a property in Kenya, be it that you're a Kenyan or non-Kenyan, what you need to know and what you need to have. With me is Stella Muraguri from MMW.
Thank you.
That is going to take us through when it comes to legal matters when you're acquiring a property in Nairobi or in Kenya, anywhere in Kenya. Stella, feel most welcome.
Thank you.
Kindly please take us through the first step when we bring for your client who has settled on a property. Let's say the client has identified a property, we've been given an offer letter, and here we bring the client to you. What do we need to know?
Thank you so much for that question. And we've come as a team from MMW, from the real estate department, to discuss that. But before we even go to the nitty-gritty, it's important to understand context. There's been a lot of anxiety when it comes to property ownership. Now, property ownership has been the subject of litigation, has been subject to disputes. And one of the things that now we are seeing with today's client is that, one, they want information, but they also want to know that even as they come to Ravi Homes, that they have a legal partner who can verify the title. We have a lot of clients in the diaspora who are buying off-plan properties. They're asking themselves, if I buy this off-plan property, will it be one of those stories that end up in the newspaper and I have sunk my investment, but there's no return on investment? Do these people have the right licenses, permits? Are they registered, the actual registered proprietors? And that property, does it even have a bank charge? That is to say, in the event the developer fails to pay, will I be told that I do not have a property because they failed to pay their debt with the bank? And the conversation today is to unpack that, because we now have a very sophisticated client. Gone are the days where people would send money to their relatives. They trust lawyers more. They have seen that lawyers or advocates are just not a cost center. They're an asset. So the conversation today, and my colleague will join us to just discuss about verification of title. Should you be owning land in your name? Should you be owning properties in your name or in a company? What are the tax implications, even tax benefits when it comes to property ownership? Something that was not there before, such as rental income tax. How does that affect you where you are? So that is a conversation we're going to have today, and I'm excited, dear audience, for you, because I'm looking at you as an investor. I'm looking at you as someone who wants to grow their portfolio, someone who wants to invest in Kenya, a very wonderful market for real estate, something that we shall discuss. So thank you for this, and we look forward to engaging more. If you have any questions, you can always, we're going to put our name, our email address, as well as Ravi Homes. So they'll put their website so that you can actually check the properties that are listed there, and then we can engage further. So to start us off, we will talk about owners verification of title. Maureen Jerry will take us through that. Thank you.
Thank you, Maureen, for joining me here. I was with Stella and we discussed a little, and I want you to take it from where Stella left. Number one, as I've mentioned, I've been in this industry for like almost 7 years, and I've served several clients from different parts of the world. There are concerns that they raise when it comes to property acquisition, especially in Nairobi, because majorly that's where most of our international clients will want to have their property. today, the reason why we decided to have this is just to actually give them the information regarding property acquisition and how our lawyers can really help them to get the best, number one, the best property that has got no issues. That's why we normally, when we have an interaction with them, we assure them that we'll put them on a safe hands, and we assure them that our partners, our law partners, will actually guide them through. We've always talked about due diligence to our clients. I would like you to take us through what it means when we tell our clients, our lawyers need to conduct due diligence on the property. Yeah.
Thank you, Vance, because I think, and from experience actually, and what the courts have stated here in Kenya, as a buyer, you have the prerogative to ensure that you've conducted due diligence, because that is the only way you demonstrate that you actually took due care at the point of purchasing the property. So when you talk of due diligence, it encompasses a few issues that I will discuss extensively during our conversation.
Okay.
And the first one, we get to investigate the title. What does this mean? You get the unit, you get the developer, and you get the buyer. And you bring them to MMW because they want a legal battle during the investment. So we get to actually confirm from the records held by the Ministry of Land whether the developer purporting to own this property is the actual owner from the records held by the ministry. Because we've had instances where we have individuals selling properties that they do not own as per the records held by the government. So we conduct a green card search, and we've had courts stating that actually as a buyer, or if you have interest in a property, then you have to investigate the root of the title. So we conduct what we call a green card search, which shows the entire history of the property from the first owner to the point where the developer purports to own this particular property. Again, when perusing these records, we get to look at whether we have any financial lender who has interest in the property, or whether there's a third party who has placed a caution on the property, or whether we have court orders barring the developer from disposing this particular property. Because we've seen horror stories whereby you just buy blindly, then you come find out that the property, number one, did not exist from the records held by the ministry, or the bank states that it had the first right on this particular property because of a loan that was advanced to the developer for purposes of construction, or we have a third party who's placed a caution because they have interest in the property. So that is the first facet of the due diligence we conduct on the property. Again, you get the developer, and we've had developers who've not had quite a good track record. So on behalf of the buyer, we get to interrogate the track record of this particular developer. So that we see whether they've been involved in court cases, whether their past projects have actually performed, whether they delivered it on time. We are basically looking at their reputation in the market, because a real estate transaction, if I'm buying property, it's largely trust-based, and the past will speak to the present. So if you did not deliver in the past, there's a very high chance you won't deliver. If you've had a good track record, then definitely we can trust the past as a developer. So after the developer, we get to ask the developer to avail the approvals issued.
Oh, the approval part.
Yes, the approvals.
Okay.
And the approvals essentially, what I mean is that you can't just wake up as a developer and decide that you're going to construct a 20 building story. You need to get approvals from the national government. You need to get approvals from the county government. We need to look at the building plan so that if you're saying the approval you've been issued with by the county government is for you to construct 10 stories, and that is what you're selling to me, at no point should you construct 20 stories without the approvals. Because you find that the county officials actually go on site to investigate this particular property, to look at all the professionals who are involved, the architects, whether they are licensed or not. The other approval we look at is from our environmental body.
NEMA certificate.
Yes. you do not want to have a developer who is putting up a project which is contravening the environment. So they get to interrogate that. And the moment we have that certificate, then it means that the credibility checks out. Again, we also get to look at the National Construction Authority, whereby the developers are registered and they need to get an approval for this particular development. Because in the absence, we've seen very many buildings either stalling, or we had a building that collapsed recently. And upon interrogation, they had not procured these particular approvals. So as a buyer, if you're really keen on getting a return on investment, these are the basics that you must do. That you must do as a buyer to ensure that everything is actually as per the record. So that in the event there's any challenge during the construction, you can get compensation even from the developer because you conducted your due diligence and able to demonstrate that anything that occurs is either due to their negligence or circumstances that cannot be tied directly to you.
Okay. A question on when while conducting due diligence on the land, do you also conduct due diligence to know the number of laws that actually are approved by the city council that can be put on that land, like on a given area? For example, let's take an example of either Westlands or Riverside. When you're doing your due diligence on the land itself, do you also get to investigate to know the number of approved laws in a given area?
Yes, we do.
Yeah.
Because when you look at the zoning laws in different areas, they've actually dictated that for this particular area, you cannot go beyond 10 floors.
Yeah, okay.
So if a developer is saying that they're going to construct 10 floors, then they must give us the approval that was issued by the county government and be able to interrogate then why is the county government contravening the zoning laws.
Okay.
So yes, we do.
Secondly, you also mentioned something to do with the green card.
Yes.
Maybe just for some people who are curious to know, what is this green card that you'd mentioned?
Okay.
Mm-hmm.
A green card search essentially gives you the history of the property from when the
Okay.
title deed was issued to the first buyer
Okay.
up to the point where the current buyer, who is a developer, intends to sell it to you. So you're able to see how the property moved from buyer 1, 2, 3. If it was only issued to the developer, then the green card search is able to demonstrate that.
Okay. All right. You also mentioned something to do with the developer, due diligence of the developer, and whereby you try to check on the records, the in terms of completion time, the construction they've done, the project they've done, and what time they completed. Take an example of a developer that actually tell people that they tell the investor that they're able to deliver in 2 years, but deliver in maybe 5 years. In your own opinion as a lawyer, what would you tell the client when it comes to such kind of developers?
The developers would have delivered.
Don't deliver on time, yeah.
Here's the thing, Evans, and from the experience we've had in the real estate sector, is that you see some of these terms are actually founded in the contract. So that if a developer purports to, or if a developer states that they are going to complete their construction, for argument's sake, by end of 2026, December, then they request for an extension and another extension. We have mechanisms in the agreement whereby if one party breaches the obligations in the agreement, you have remedies. You can either rescind the agreement, you can cancel the entire transaction, and based on that, they should refund the entire purchase price paid to you. We've also had instances where we've negotiated that if a developer delays, then the buyer is going to get, if they're looking to rent out the apartment, be able to look at the rental yield monthly. And if there's any delay, then the developer is the one to cater for this cost, and it's paid directly to the buyer. So that the buyer does not suffer losses due to the developer's delay.
Okay. Yes. Thanks so much for answering that question, because that is something that actually most of our clients are so keen on. There's what developer promises and there's what they deliver.
Yeah.
I don't know whether you also would be keen to know in terms of finishing, or you don't go through that. Well, whereby the developer, the show house looks really nice, really good, really well done, but now the final product, what will be handed over to now, the buyer, is totally different from what the show house dictates. Do you really also look into that? On how, or how do you help a client whereby whatever they saw in the show house is different from actually what they now getting? Yeah. What remedy do you have for that?
We do have remedies in the agreement, and yes, we look into it because when you look at the contracts, or first, when you look at the first point of engagement with a developer, you find that most buyers actually take pictures or recordings. You also find that the developers have content online whereby they're advertising that this is our showroom and this is a dream that we are selling to you. So how do we farm that up in the contract? We ensure that if a developer states that the finishing will be of this quality, then it is actually reflected in the contract. If you're talking about the amenities in the project, they're actually covered in the contract, so that if they do not deliver on that, then a buyer can seek remedies before a court of law.
Okay.
Yes.
Yeah, I mentioned that because I had a client who actually was very much concerned at the beginning because most clients buy off plan. And at off plan stage is what is being presented. You're not seeing the actual thing. So kind of they told the developer to write it down on the agreement. And the lawyer for the developer was like, we can't put it in the agreement. How you as the advocate for the client force this thing onto the developer to ensure that it's effected on the agreement? Yeah, is there something that should be done, or is there a law that actually helps the client to that protects the client? Because if it is not put on the agreement, which I sign, the developer can decide it's not there's not something that we agreed on, and they just bypass it like that.
Yeah.
So, do me as a client, can I go to court? Can I sue the developer? Can I sue the developer if whatever we agreed? When we agreeing, sometimes back, and when the product is ready. So if it's not delivered as per the agreement, maybe it was a verbal agreement, a promise that we were to deliver this product, and it was not captured on the agreement.
Yeah.
So when I have my final product and I find that it's not actually as per the way we've agreed, as a client, through you as my advocate, can we sue the developer?
Yes, we can. And what we always advise our clients is that any verbal conversation that you have with a developer, particularly touching on finishing, quality, anything touching on this particular unit that you're investing in, it must be reflected in the agreement. Because if you're going to go to court, and knowing that Kenyan courts are court of record, I cannot go to court and claim that you had a conversation 5 years ago whereby you told me you're going to have ABCD in the unit and it was not effected. Then how do you prove it? When we engage with a purchaser, we get to have a feel and an understanding of the conversation they had with the developer in the first instance. We're also able to interrogate the developer so that we have a schedule. We've actually not encountered a situation whereby a buyer or a developer is not willing to have that schedule, because if you're promising to have this and this is what you're presenting to me, then we might as well reflect it in the agreement so that if they do not deliver on that, we can go to court and enforce this particular contract. So yes, a developer can actually be taken to a court of law as long as the terms are in the agreement.
Okay.
Yes.
That's okay. Now that we've conducted the due diligence and now you found either A or B, depending on the report that you've gotten from the due diligence, how do you move forward? Or what are the kind of reports or the results should we expect after conducting the due diligence?
Okay. So, as lawyers, we conduct due diligence, right? We are going to prepare a very comprehensive due diligence report for the purchaser, where we highlight that we've looked into the property, and these are our findings as per the record held. We've been able to look at our judiciary portal and any decided cases, and whether we've had any orders that would bar the developer. So essentially, all the issues I've touched on due diligence, we now compile them into a report. And from a risk perspective, if, as lawyers and from our assessment, we do not see any risk exposure in the client investing in this particular unit, then we're able to advise them to proceed to execution of the letter of offer.
Okay.
We're able to advise the client to proceed with executing the offer letter and paying the deposit.
Okay.
We also have another scenario whereby we've had developers actually volunteering information stating that there are some documents that they are waiting for them to be issued by the different regulators or the government, and they're requesting for time. So in such a case, we still issue the due diligence report to the client, and we tell them that we can wait for this particular time as advised by the developer. Then we can now move forward to sign the offer letter and pay the deposit. Because the problem is, the moment you sign and the moment you pay, it means that you've already kickstarted the entire process.
Oh yeah.
Yes.
That's okay. One thing I was forgetting, it's this one touches on off-plan projects, especially the one that are just complete off-plan. This is whereby the developer has gotten most of them, and say most of the approvals that are required, and maybe the one that normally tends to pend a lot is the one that actually is called the NEMA certificate,
Yes.
National Environmental Management Authority certificate. So we've seen developers encouraging buyers or the investors to do a booking for the unit that they're interested in, and maybe have a clause that state that if it happen not to get the approval of NEMA, we will refund.
Yes.
I don't know, what's your opinion on that? Will you encourage the client to proceed, do a small deposit as they wait for all the approvals to come out? Probably, I would say maybe two or three certificates are pending. Would you encourage a buyer to go that direction?
In some instances, we've actually done it, but it also depends, because if you're talking about the NEMA certificate, we ask for the application lodging or their request to NEMA to be issued with a certificate. And what do we do this kind of a certificate? We go to their offices and we're able to have a sit down with the NEMA officials, where we get to have a discussion on whether the application, first of all, is valid and whether they foresee them not issuing this particular certificate. Then in that case, we can advise a buyer to pay the booking fee, as long as we set a timeline for the developer, so that we're saying that within a month of paying the booking fee, we need to procure this particular certificate. If you do not have the certificate, then the funds can be refunded within 7 days or 14 days.
Okay.
But some certificates we do not compromise on, like the National Construction Authority. We can never, under no circumstances, allow our clients to proceed with payment if the developer has not procured this particular certificate. So it's on a case-to-case basis, and also having a sit down with the government authorities to assess whether they are going to issue it or not.
Okay.
Yeah.
I don't know whether you mentioned it. Do you normally, if I bring for your client, not in Kenya, maybe has never been to Kenya, you as the lawyer who is representing them, do you do a site visit?
Yes, we do. We do conduct site visits because we are their eyes and ears on the ground.
Okay.
And we're even essential in the first place.
Oh yeah.
We've had horror cases whereby a client paid, they are very diligent in terms of payment of the purchase price, but on this other end, the developer is not making any progress. And had the client taken time to engage a professional who is actually on the ground, then such a situation could have been avoided. Because what we do is that if you're given quarterly payments, before you make any payment towards the purchase price, we are actually able to go on site. We have clients who prefer video calls when we are on the site. We have other clients who prefer we take videos of the progress and pictures, then we share with them, and we give them the go ahead to proceed with payment of the purchase price. So yes, we conduct site visits, and based on our finding, we then advise them to proceed and make the payment. If the project is not proceeding as per the milestones guaranteed by the developer, then we get to reorganize everything in terms of the payment schedule.
Okay.
Yeah.
Okay. Thank you so much, Maureen, for taking us through on due diligence, and we are very much grateful. And for us, we say thank you, and yeah. we've seen you've taken us through the due diligence part. I want you to take us through another process and like a documentation for a client who is purchasing a product. There are things that they need. I've had a developer who actually wants this thing uh, at the onset of the engagement of them. Number one is the KRA pin, and the second part is RDSASA.
Yes.
So I want you to take us through the two, why the two are very important. KRA pin, Kenya Revenue Authority pin, and RDSASA account.
Okay.
Yes.
I will begin with the Akisasa account. Yes, we have a platform called Akisasa, and it's an online platform rolled out by the government, and specifically within the Nairobi area, where land transactions are conducted online. And this is a very secure platform in the sense that first I need to be onboarded as a buyer. A buyer needs to be onboarded on the Akisasa platform, and you're going to be issued with a very unique identifying number. And you're the only one who can get access to this particular platform because we have the backing of the OTP code.
Okay.
That you are the only one who can access this particular OTP so that you can access your account.
So this OTP is mapped to my phone?
Yes,
or
and your
my
email.
Okay.
Precisely.
All right.
And this is the information that you now give the ministry at the point of onboarding on the Akisasa platform.
Okay.
Because you need to give them a secure phone number and a secure email address.
Okay.
Because if anyone can get access on the platform to your account, then they're able to transact on your behalf.
Okay.
Because the properties are onboarded on the platform and you actually sign on the platform.
All right.
Yes.
Okay. And the process of getting Adisasa, where do I go to the bank to open the account at Adisasa? How do I open the account?
Okay.
Do I go to the Ministry of Lands or how do I do it? If I'm, like, for example, have clients who are not Kenyans, do they need to be in Kenya to open the Adisasa account? Or they don't have to be here?
They don't have to be here.
Okay.
They just need to reach out to MMW Advocates because we have a direct link with the Ministry of Lands, whereby we're able to engage the Akisasa team and have them open an account on behalf of the foreigner. But for the Kenyans, they're actually able to go on Google and just key in Akisasa and open the account because they have a national ID, which is used at the point of opening the account.
So you mean as a Kenyan, I just need an ID?
Yes.
And that is it.
You need an ID, a phone number. We have the primary information that you must have is the ID because that is what will be utilized together with the additional information now on your identification card. But as a foreigner, since you do not have an ID, then you have to go through the lawyers who will facilitate the opening of the Akisasa account.
Okay. Just a minute.
Yes.
A Kenyan who has been living in diaspora for quite a long time. So they went there when they were young. They don't have an ID. They only have maybe a passport, maybe from the other country.
Yes.
Can they open it?
No, they cannot.
Okay.
Because the system only recognizes the national identification card. Then that means if you do not have your ID or if you do not remember your ID number, then again you have to go through the lawyer so that it can be opened on the bank level.
Yes, I recently we tried with my client to actually change her ID. And we realized that the error that we are getting is about the serial number of the ID. The system only recognizes the first serial number of the national ID. What do I need to do as a Kenyan who actually cannot register because I had replaced my ID?
What that particular individual can do? The first option, which I think would be the easiest for them, is again to engage MMW because when you look at the Akisasa system, it's linked to other systems that provide government services to the citizens.
Okay.
So if you're talking about the register of persons, the reason as to why the system can pick out your details, it's because the system is directly linked to the register of persons. He's the custodian of your primary information. If you're talking about taxes, then the system is directly linked with our Kenya Revenue Authority. So as MMW, we're able to reconcile all this information. If you changed your ID and your serial number was changed in the process, then we can engage the stakeholders and align the information.
All right.
Yes.
We also mentioned about Kenya Revenue Authority PIN. Why is it important for a foreigner to have the KRA PIN?
It is very important because we must pay taxes, don't we?
Oh yeah, sure.
We have, in as much as it might be painful, we have to pay taxes at the end of the day.
Yes.
And if you're investing in the real estate sector in Kenya, then you'll be subjected to taxes, one of them being the stamp duty tax, which is a tax payable at the point of purchasing the property. Now, we have Kenya Revenue Authority, which is a body in charge of the taxation regime here in Kenya, and imposing taxes and regulating essentially the tax ecosystem.
Yeah.
And for you to get the certificate, then you need to lodge an application. And for foreigner in this case, you need to demonstrate that you're investing in the real estate sector, and you need to avail a couple of documents as proof of this particular investment. One of them being an agreement for sale. So that they can see you've engaged this particular developer, you're buying this property, and they're able to issue you with a KRA PIN certificate, which has a very unique identifying number, only identifiable to you. So at the point of paying taxes, then it's directly linked to your account as a taxpayer here in Kenya.
Okay. So as a foreigner who will want to have a KRA PIN, there must be an evidence the reason why you need the KRA PIN.
Yes, as a foreigner. Yes.
As a foreigner, yes.
Yes.
So, for example, someone who's buying a property, now they can present something like an offer letter. And is an offer letter accepted or sale agreement?
An agreement for sale, because that is conclusive.
Okay, an
Yes.
agreement for sale.
Yes.
Thank you so much for taking us through that. We really appreciate. And if you have any inquiry regarding the processes, MMW and Ravi Homes will be able to help you get your KRA PIN and have this as account. Maureen,
Yes.
I've seen quite a number of foreign investors actually who are moving to Nairobi, courtesy of our good weather and security. And Kenyans are warm and welcoming. We don't have issues with foreigners. We always welcome foreigners to our country. And a lot of them are coming to Nairobi and actually are investing here, and especially in property. We've seen them investing in land, we've seen them investing in houses, we've seen them investing in apartments. So there's this one question that normally pops up when it comes to a foreigner investing in Kenya. Can I own a property on a freehold?
No. A foreigner cannot own freehold property.
Okay.
Because when you look at our Constitution 2010, Constitution of Kenya 2010, it has stated that foreigners can only own properties on a leasehold tenure for a period of 99 years. So if you get anyone purporting to sell you a freehold property, then you cannot own that property legally as a foreigner.
Okay.
No, you cannot.
So as a foreigner, how do I own the property? Under what tenure? Or under what category?
You own the property as a foreigner under the leasehold tenure for a term of 99 years, which of course you can get to renew 5 to 10 years before the lapse of the 99 years.
Okay.
Yes, or the term indicated on that particular title deed.
If I'm buying an apartment in a complex, what kind of titles will I be getting? Me as a foreigner or as a Kenyan?
When investing in an apartment,
Yeah.
you're going to be issued with a sectional title deed, which has been backed by the Sectional Properties Act. And this means that you will get a unit you will get a title deed for your unit, and the title will indicate the unit's number and the number of shares you have in the common areas that are jointly owned together with the other unit owners.
Okay.
Yes.
This thing that we have also our own Kenyans asking me as a Kenyan, can I own a property and a section of property? Can I own it, and especially in an apartment, as a freehold?
No, you cannot.
Okay.
No, you cannot, because you find that most developments are within central business districts.
Okay.
And you find that what the government has done
Mhm.
is that they've not allowed individuals to own this property on freehold tenure.
Okay.
They are the head lessors, then they get to
Okay.
lease the property
Mm.
to now the unit owner. So that if you do not renew your lease,
Mhm.
then there's a risk that your property can revert back to the head lessor, who is the government.
Mhm. Yeah, this actually goes to Kenyans who are planning to buy property and they're thinking that you can own uh, an apartment in maybe Westlands, Limani, or wherever within the municipality under freehold. It's not just possible. It's the government can only give you a sectional title, which is a freehold, a leasehold
Yes.
title.
Yes.
Yes. Thank you so much, Maureen, for taking us through on that. And we really appreciate your input on that. At least it has helped our clients to
Yes.
know what kind of categories of ownership they can get while buying an apartment in Kenya. Thank you so much. Hi, Stella.
Hi.
Thanks, you're back. We are having a chat with Maureen.
Yes.
And we've just touched on some several topics. Number one, we've looked at due diligence.
Yes.
What clients need to know before they start even thinking about buying the property.
Yes.
We've also touched on sectional title ownership,
Yes.
sectional ownership, and also freehold ownership. We've touched about foreigners who want to own property in Kenya.
Yes.
Now, I want us to move to the next level, and this next level is whereby the client actually has decided to proceed with the property, has done the 20% as per required by the developer, and the developer has issued them with a sale agreement. Yes, so most at times, or if not all the times, we always encourage our clients to have a lawyer to review the sale agreement because it has got some law terms that they might not understand.
Yeah.
I would like you to take us through the content of the sale agreement. What kind of things that clients should actually be keen on when it comes to the sale agreement?
Okay, thank you so much for that. First, a sale agreement is just, or an agreement for sale of property is basically an agreement that details what are the terms within which the purchaser and the buyer are willing to engage in so that the property is transferred. Okay? So just look at it in that way. How are we agreeing for this sale to happen? It's as simple as that. But if I am a layman, of course, I must involve a lawyer because you have to remember that you are acquiring legal rights. At the end of this, your plan is to acquire legal rights in terms of how you'll own this property.
Okay.
But from a foundational level, if I'm a layman or just an investor, local or foreign, what are some of the things that I would look at? Number one, even just from the first page, who are the parties involved? Right? Because if I'm able to identify who are the parties involved, I'm able to confirm the people I'm paying money to and the people who are actually titled as the vendor, the developer, or the person selling as a seller. Are they the ones then listed on the title?
Okay. Yeah.
Right?
Yeah.
So then you do not find yourself in a situation where people are saying they give it to a land buying company, but then the person registered is a different company. So, or even how we find that you may find a company has a different name as the developer, but what is on the title is something very different.
Oh, yeah.
So how do we ensure that you're dealing with the right party? So right parties, then is that property that you're paying for? Is it actually, because I'm sure you've talked about the search.
Yes.
You did a search. Is that property as listed in the sale agreement the property you're buying?
Yeah.
Okay. If you decided to buy a 2-bedroom, has it been titled 2-bedroom with DSQ, without DSQ? Please be curious about those things. So that also you do not come and say that you are shown one room or one property, but the sale shows something different, but you're coming at the end of that particular process. And that's what I'm saying. I want it to be from a foundational level, even before we go to complex issues, so that we have very prudent purchasers. Then look at the purchase price. You may have negotiated. Negotiated what? The actual price itself.
Yeah.
How you're going to make a payment.
Yeah.
Right? So if you're going to commit to a sale agreement, because a sale agreement is a binding document, make sure that are you making sure that the purchase price is what you agreed on? Assuming that you're going to pay it in installments, are those the amounts that you have agreed on?
Yes.
Remember that this window is the only time you can negotiate those terms. Once you have put pen to paper, you have bound yourself with those terms. And that's why I'm just going, line by line in terms of what you would review, right? Then, for instance, if it is an off-plan property, of course, you'll make sure that if it's a 2-year project, you make sure that you tie those particular payments to milestones. You may find that, and I'm sure you've seen this in your experience, just as we are in this space, where you find that the project is completed in 2027. How would you then stagger the payment until that particular period? Do you just pay even if the project is not progressing? Those are the questions that now they come to you from your commercial perspective and for us from a legal perspective. How do we make sure that payment is actually tied to milestone? If you are meant to have been on a particular milestone, then make sure that that is the milestone that there is. And also on payment, how do you make sure that in the event that there is a default or delay on your end?
Yes.
Because you and I run businesses, and sometimes there's ups and downs, or you find that funds are committed to something else. You also look at the flexibility before they decide to actually, the developer decides to say that we are not willing to progress with this particular transaction. It might be important at that point to look at the flexibilities before a contract is actually rescinded on account of you not paying. And I say that is the time you actually negotiate it. And then also, in the event that the developer or the person who is selling the property to you, the vendor, fails to actually undertake certain obligations, what obligations could this be? Perhaps it's you're buying a maisonette or a bungalow, and you are promised vacant possession. Then you find that the tenant who's there, as happened with one of my clients, the tenant who was there from the previous landlord did not want to move out.
It happens.
It happens. So then, at that point, you remember that is not your tenant.
That's not your tenant.
It is the vendor's or landlord's tenant.
Exactly.
So you must make sure that payment is tied to those particular conditions, so that then you do not have a situation where the vendor has received their money, but there's no reason for them to be in a rush to get the landlord out, the tenant out. Yes. So payment plan is something that is so fundamental because then it actually can be a very frustrating process. So ensuring that what conditions need to be met before I give you the final payment. Are there certain completion documents that need to be given? Is it a title? Is it a lease? Now that we're talking about sectional properties, quite obviously you may find that title may not come out at the same time the building is completed because of issues to do with georeferencing. So your client may come and tell you, but I do not have a title. So at that point, you should then be able to explain to them, you have vacant possession, you are the owner of this particular property. It's just that now for apartments such as this one, it may take time to get the title. Right? So that then you do not have very angry clients who are saying, I did not get the title, and Stella said, I must get the title. You must get the title. But also at that point, understanding that your referencing must happen for you to get that sectional title. Right? Then also, what happens again when there is default on the side of the developer?
Stella, there's always a burning question from the clients, especially when it comes to an ongoing construction or an off-plan development. Number one, the first concern is, what if the developer does not deliver on time? They had promised to deliver this by end of the year, but come the end of the year, the project is not ready. From the lawyer's perspective, or from your own wisdom, how will you advise this client?
Yes. And we actually did a transaction such as that one where the biggest argument was delay may happen. And it's inevitable because such is life. One of the things that we ensure is that in the contract,
Mhm.
in the event there's delay, it
Mhm.
must be communicated.
Mhm.
When it is, because delay could be 7 days or 10 days, but it must be communicated.
Mhm.
And make sure that there's a notice saying that please communicate whenever there's a delay.
Mhm.
Okay? Now, if then the delay means that the entire development has been suspended
Mhm.
or cannot proceed for whatever reason, or there was mismanagement of the project, now it can't proceed.
Mhm.
One of the clauses that would make sure that is in that agreement for sale is actually a clause saying that in the event something like that happens,
Mhm.
you refund the entire amount.
Okay.
Because the promise that you gave me as a purchaser or as an investor is that if I invest and put my money here, what I'll get out of it is an apartment. Now, if you cannot then produce that particular investment that I had asked for,
Mhm.
then return my money. It's as simple as that. Refund me my money.
Mhm.
So then you push for a refund. And it's important that that clause is there,
Okay.
because you may find that the suspension of the contract may not be due to existential issues such as act of God. It's just mismanagement of the project.
Okay.
Ensure that that clause states that it actually you get a refund.
Yeah. Let me ask you on that. You, as my lawyer, as my advocate who is representing me on this transaction, are you going to be with me when it comes to this kind of scenario whereby a refund need to be done?
Yes.
Are you going to help me to get my money?
Yes, that's a very good question.
Mhm.
Now, the role of the lawyer does not end at the point of a sale agreement.
Mm.
It ends at the point where you actually get the title. And that is why I find it almost laughable, if I may say, where I find people tell you, just review the agreement.
Mm.
But until the title is in your name,
Mhm.
or the process is done, you will still need that lawyer to walk you through that journey. So yes, we will actually help you in terms of drafting the demand if a demand is needed.
Mm.
We've had a situation where you can sometimes even, get orders for specific performance saying, refund me my money.
Mhm. Mhm.
And you may find that it's not that developers are necessarily fraudulent.
Mhm.
It's just that things can go wrong.
Yeah.
Right?
Yeah.
So yes, get into the sale agreement with great aspirations, but also remember that lawyers are meant to look at the risk element
Okay.
and then cover that risk.
Okay. And in the event whereby it's the client from the client side, maybe client has run into financial problems and clients will want to pull out. What do they stand to? What do they stand to lose, or what kind of risks do they have when it comes to a point whereby they have to pull out from the project that they've started paying for?
Yes, and it happens.
Mhm.
I mean, look at what COVID did.
Mhm.
We are currently in a very repressed economy, so people who were CEOs or top executives are no longer earning what they used to earn or are being declared redundant. So these are realities.
Yes, yes.
And in such situations, then we have a clause that provides that, and this happens with developers. They state that they will actually retain 10% or 10% of whatever it is that you had paid will be forfeited and retained by the developer. So in such a situation, it's important that the moment you know that you cannot complete, you can either get into negotiations. Maybe there'll be money that's coming in later.
Oh, yeah.
Or you're about to get another job, you can get into negotiations. But if you know for sure you cannot complete that project, communicate it immediately, so that then we can actually communicate on your behalf to the developer. You're able to get a refund, less than 10% forfeited, for the inconvenience that you have caused that developer. Because you've caused the developer an inconvenience.
Sure.
Yes.
Okay. Then we have another scenario
Yes.
that I want you also to touch. We've had clients who are not willing to proceed with their own lawyers, and they will want to use the developer's lawyer for the transaction. If something goes wrong, the lawyer for the developer, who are they going to represent?
Yes.
So are they going to represent the client, or they're going to represent their own client, who is the developer?
You could not even have put it any better, because it's a conversation that I have with fellow lawyers and colleagues where we ask ourselves that same question. And I want to challenge the mind of the investor who's thinking, I'll save costs. And even sometimes lawyers tell developers lawyers tell the purchaser, I can act for you. Now, can they actually do that? Yes, they can. But is it the right thing? No. There's nothing illegal about it, but commercially it is not a sound decision. Why do I say that? In the event there is conflict, we've just spoken of a situation where your lawyer is for the developer and the development can no longer proceed. Assuming the government comes and says, this project is actually happening on riparian land, right?
Yes.
So at that point, do you truly expect the developer's lawyer to also start pushing the developer to ask to give you a refund? It might be very difficult, right?
Exactly.
Or you are the one who has defaulted. Now, will they write a letter on your behalf to themselves saying that you have defaulted?
No.
Where there may potentially be an issue between the developer and the purchaser, or you, the investor, you can be certain that the developer's lawyer, and that's what we call them, the developer's lawyer will act in the interest of their own client. And their first client or first in time client is actually the developer.
So me as a buyer, being represented by a developer's lawyer, I'm a secondary client to this lawyer.
Precisely. And even now, think about it from a due diligence perspective. I already have the title. So am I likely to do an independent search as the lawyer for the developer?
No.
Because my interest is also ensuring that I'm just closing sale agreements, because that is how I earn fees. You need an independent counsel or lawyer who actually can tell you everything that is in the sale agreement is valid. Similarly, if I'm reviewing my own sale agreement as a developer's lawyer, I'm the one who has drafted the sale agreement.
So you would not even review it?
Why would I review what I have drafted? It is my best work.
Exactly.
So there is a conflict of interest there, and I would urge investors, people who are purchasing properties, get independent counsel. Your interests are not primary to the developer's lawyer or to the vendor's lawyer. Yes.
Another thing that actually has come out in several occasions with my clients is a clause that actually is in the sale agreement, and that clause is, I think it's something to do with force majeure.
Force majeure.
Force majeure. It's I don't know whether that's a French word or.
Yes.
Yeah. Can you just take us through regarding that clause and why it's most times is something that normally comes out whenever I have a client?
Yes. So force majeure is actually something I've litigated on over and over. And force majeure simply means that there are circumstances outside the control of the developer, the vendor, or what you call a seller. I'll use the word vendor to mean seller. There are circumstances outside the developer's control that have made it impossible to actually complete the contractual terms or for them to meet their contractual obligations. So the contract cannot be completed or performed as had been initially intended. Now, one of the things that we look at when it comes to force majeure is that these things must be unforeseeable and must be unpredictable and are outside the control of the developer. Okay? So, what are some of the things, if we were to draw an imaginary table here, what would fall under force majeure and what would fall under not force majeure, if I can put it as lightly as that?
Yes.
Now, if you're talking about delays, that is not force majeure.
That's not force majeure.
You should have planned better.
I've seen some developer putting it under force majeure.
It is not force majeure. Because delay is not unpredictable. It can be cured. You remember, force majeure should make the contract impossible to perform. Right? And this is also to lawyers who insist that those should be clauses that are within force majeure. I'd urge you, please look at what the courts have said force majeure is.
Yes.
If you're going to bring it to a lawyer like us at MMW, we're going to reject it. Delay is not force majeure.
It's not force majeure.
Okay, so your casuals going on strike is not force majeure. That's another delay issue. Poor planning is not force majeure. Lack of material
It's not
is not force majeure because you can source it from somewhere else.
Somewhere else. So technically, force majeure means something beyond control.
Exactly, beyond the control of the developer. So what would it be then? Acts of God.
Acts of God, yeah, sure.
So if an earthquake happened on a property that you are purchasing, surely that is not foreseeable. If there were floods that came and completely washed away or made or ruined that particular project, that is definitely
Do you have an insurance that can cover this?
Precisely where I was going.
Oh, sure.
Now, one of the things that a lot of people have been complaining about, investors who are investing in Kenya, is that there is no insurance requirement in our law by developers. And what we have been seeing recently is that a lot of developers are now insuring their projects. And because I equally as an investor, that is one of the things that I look out for. Is there an insurance over this particular project? Because assuming there is something that actually brings down the project, right? I would want to find out, will I be compensated? Because you can imagine equally, the developer had not foreseen this. You said it's unforeseeable. So will they be able to refund me? Me and 100 other people who have purchased that property? Potentially not. So then what does a prudent investor do? Ensure that some of the issues that are on that force majeure clause, are they covered by insurance as a risk mitigation measure? Yes.
Just to ask another question. We saw a development that came down, and the investigation revealed that they went beyond the approved number of floors.
Yes.
So will that developer say that this is now a force majeure?
Of course not. Remember, there are always architectural plans that have been approved. So, and there's even a court case to that, and I will come to it, that happened in Mombasa to that effect. Now, if you've gone above the particular zone, like let's say in a particular zone you're supposed to go only to 10 floors, you decide to go to 12. And the county says they should all come down. That's not a force majeure issue.
So I should be entitled to full refund?
You are entitled to a full refund because you tried to be very greedy and clever as a developer to go over and above what that particular zone allows, right?
Okay.
Similarly, now to the case in Mombasa, what happened? The project had said they would go up to 15 floors. But the developer saw there's an opportunity to add more units. Now, the purchasers went to court and said, you said we are only buying up to 15 floors, but we are seeing you continuously adding more floors. And the court actually went back and stated that when these particular investors were investing in that property, they had been shown the architectural plans, and it showed that it would only be until 15 floors.
Yes.
Adding more floors when they have already purchased those properties is unlawful and is actually then in breach of the contract. So it was stopped. So even you, as an investor, you have a recourse in such a situation that if a developer decides to now go over and above or going beyond the contractual limits of what they had promised you or what they had represented you, you can go and say that they should be stopped, or what you call, it's a doctrine called estoppel. You are stopped from actually going against what you had represented to me. Yes.
That's very insightful.
It is indeed.
Thank you so much, and we're very grateful having you here and trying to just show us what are the contents of the sale agreement, what we need to look out for, what we need to be cautious on. And this one is very, very, very helpful for our clients who are looking to buy property in Nairobi or in Kenya or wherever. Yes, thank you so much, Stella, for being here. We are grateful.
Perhaps I could add a parting shot.
Yes.
The parting shot would be one, involve a lawyer. You can be a good investor.
Involve a lawyer.
Yes, involve a lawyer.
Involve a lawyer. An independent lawyer from the developer's lawyer.
That was my second point. The developer's lawyer is not your lawyer.
Yes.
because we are talking key takeaways.
Yes.
The developer's lawyer is not your lawyer. Have an independent counsel review your documents. Just because you have been successful as an investor doesn't mean that that makes you a lawyer. You know, I've had investors say, I've done mini sale agreements.
Oh yeah, sure.
But doing mini sale agreements does not preclude you from issues that happen when it comes to when conflict happens, when things go wrong. Remember, the world is evolving. So leave the things of the past. As the world is evolving, ensure that you look at a lawyer as an asset and not a cost element. So thank you so much.
Thank you so much for taking time to watch our video. Today we had our partner, which is MMW LLP Advocate. They were just taking us through the process when you identify a property in Nairobi, what you need to know regarding the property. That is the due diligence part, the sale agreement part, and the kind of titles that you expect to get. On our next video, we'll be discussing taxes regarding acquisition of the property, renting the property, or disposing the property. We'll also touch base on what are the costs associated with the property. Apart from the purchase price, what are the other costs that are associated with the property? If the property is 10 million, what are other costs that you need to expect when you're acquiring this property? If you have any comment, please go to the comment section. You can subscribe for more alerts when we put our videos. You can find us on Facebook, find us on Instagram, and also on our website, ravihomes.co.ke. We'll be glad to hear more from you and interact with you more. Thank you so much.